So, friends, what we will do is to move on to the next topic uh, for our discussion, and that is the topic on Union of India and its territory. As you know, friends, Article 1 to 4, which is Part 1 of the Constitution of India, deals with Union and its territory. And these four articles tell you and describe you what is the Federation of India in terms of the Federation of States and what is Bharat as the Union of States. Uh, Absolutely, one will understand that the traditional name in India is Bharat and the modern name is India. And hence, you will notice that the Constituent Assembly had adopted a mix of both India and Bharat quite often. Now, if you look at it, when we talk about Federation of States, you will notice that while we are talking of Federation of States, it's not spoken in terms of what is there in the United States, but here you will find it's a different form of state that we see in India. And when it comes to the territory, you will notice that India has a territory in which the states also have certain kinds of territories. So the union is a part of the territory that we have, and it is also the union territories which are administered by the central government. So I think while we say that state has a territory, that state territory is not a sovereign territory. That sovereignty of the territory belongs to the union. But of course, for kind of a federal governance and for public administration and application of public policy, I think the states have been divided in India as the division of union per se. So when I say union and its territory, friends, what does it consist about? I think it consists about all the territory that have been constituted as states, which are around 28 in number, and union territories, which are around 8 or 9 in number. So you will notice that these states define the territory of India. Also, one should understand that India is one nation. It is an integrated nation which is not divided into states, but it's an integration of those states. Um Also, you will see that there are certain states that have special provision for governance under the constitution. That is because of special circumstances. We will probably take some discussion on it. But just to tell you that the constitution does provide for the fifth and the sixth schedule of the constitution, which contains certain special provisions in respect of administration of scheduled areas in tribal states within certain of these states. So that is how it has been constituted as of now. So in 1956, you will notice that just after we adopted the constitution, the country had only 14 states and 6 union territories. Over a period of time, that has increased to 28. And you will notice that some of the union territories have been declared as state, and they include Himachal Pradesh, Manipur, Tripura, Sikkim, Goa, Arunachal Pradesh, and Mizoram. Also, you will notice that it is important that to maintain the sovereignty of the territory of India or the land, uh, India can actually have foreign territory being acquired, conquered, and you will notice that this could be taken under a treaty. It could be taken on lease. This is under international law, or it could be annexed to the territory of the Union of India through what we call as occupation. So, Goa, Daman, Diu, Puducherry, Sikkim, and Dadra and Nagar Haveli are some of these territories that have been taken to the Union of India. However, you'll notice that all these territories were under some kind of foreign occupation. So that is something that one will have to take due note and consideration of. Uh, so, of course, you will notice that time and again, when we talk about Article 2 of the Constitution, Article 2 empowers the Parliament to admit into the Union or establish new states on such terms and conditions as it thinks fit. That is what the Parliament can do. And please note, when we talk about Article 2 of the Constitution, It grants two basic powers to the Parliament. First, the power to admit into the Union a new state, and the power to establish new states. These are two powers that the Parliament has. So the admission of states is some kind of a provision where maybe a foreign territory is declared as a state and admitted into the Union, or it could mean that some part of state reorganization or readjustment, which is an internal issue, can also be made by the Parliament. Article 3 of the Constitution talks about the authority of the Parliament to form new states by separation of territory from any state, or by uniting two or more states or parts of the state of any territory thereof. Article 3 also empowers the Parliament to increase the area of any state, diminish the area of any state, alter the boundaries of any state, or alter the name of any state. And interestingly, you will notice that any such bill is not necessarily considered as a constitutional amendment. So, state reorganization or state territory annexation is not necessarily some kind of a constitutional amendment, and it's not some kind of a major process that is involved. So the bill to look at territorial readjustment in the Union of India can be introduced by a simple majority. However, even before it can be used and passed by a simple majority, such bill can be only introduced with the prior recommendation of the President of India. And the President is duty bound to refer such kind of state readjustment bills to the concerned state legislature for expressing their respective views. And once such views have been made by a simple majority, those bills can be brought into existence and act, and the state territories can be readjusted. So that is what is very clearly mentioned in the Constitution, and hence this kind of readjustment or reorganization of the state is not a constitutional process necessarily, though it is defined between Article 1 to 4 of the Constitution of India. So it does not require a constitutional amendment. But you will notice that though it does not require constitutional amendment, most of the state reorganization and readjustments have happened through constitutional amendments. Um, Article 4 of the Constitution declares that the law made for admission or establishment of new state or alteration of the areas and boundaries of the names of existing states are not considered as amendment under Article 368 of the Constitution. So that is what Article 4 actually states to the extent. Now, the Supreme Court, in a case in 1969, has ruled that the settlement of boundary disputes between states or among states is something that can be definitely the prerogative of the Parliament. And hence, you will notice that the territory of India is something that the Union of India owns, and the Union of India has the ultimate power to reorganize, readjust the territories of India amongst the state or amongst the union territories, as the case may be. Also, it is the power of the Parliament to decide which territory will be managed by the Union government through the President of India as union territories, and which of the territories will be managed through a state government, and statehood can be granted to such kind of territories. Uh, Now, friends, moving forward, you will notice that the Union and its territory, the Union of India and its territory, is not confined to mainland. It also extends to islands, islands such as the islands in Lakshadweep, which are on the western side of the country, which are in the Arabian Sea, and Andaman and Nicobar Islands, which are in the Bay of Bengal. These are a large number of islands that are also part of the territory of the Union of India. And please note, while these islands are not only important for strategic purposes, they are an integral part of the mainland India. And because these islands are important, they have been kept as union territories time and again. And you will notice that these are how the territory of India gets extended. Now, you must be saying, why are we speaking about Union of India and its territory in terms of islands? It is simply because if you apply issues of international law at this point of time, you will notice that from these islands, what is India's exclusive economic zone? What can India explore in terms of the seaward area of land is also considered as the territory of India. So you will notice that under international law, especially under the law, United Nations Convention on the Law of the Sea, all of these then becomes very important, right? Because they are some kind of extended territory for economic activities and economic purpose, which we say as what we call as the horizontal and vertical territory of the Union of India. When I say vertical territory of the Union of India, I'm speaking about the airspace, which is form of the territory of Union of India. So it is land, it is air, and it could be apart from being vertical, it can be horizontal, which means it is like this, which means you then try and measure the territory of the Union of India, and under international law, that kind of horizontal measure includes what we say as the 12 nautical miles as the territorial waters. So it is territory means not only territory on land, it also means under international law territory of water as well. Not to forget, friends, it is important for us to, at this point of time, also discuss maybe in some detail about Delhi, which is the administrative capital of the Union of India, and Chandigarh, which is the administrative capital of two states, which is Haryana and Punjab. Now, these two are cities per se. However, you will notice that these two cities have been kind of a challenge and a problem because of claim that exist. Delhi had to go for full statehood, but unfortunately, it was not granted full statehood. So it is a unique state with limited powers. And Chandigarh, which was supposed to be a city, and both Haryana and Punjab actually claimed for the same. So some of these cities or some of these territories had to be granted some kind of a special status so as to amicably resolve territorial disputes, not only between states but also between governments, as the case may be, or between local representatives, as the case may be. Because the history of creation of states, friends, has been a kind of a volatile situation, because very time and again you will notice that many of these state reorganizations have happened due to some kind of a protest, due to some kind of an agitation, due to some kind of a demand. And many of these states were created basically on linguistic lines, but not necessarily so. And hence, keeping the demand of the population and the need of the political process at that point of time, I think the division and readjustment of states is a continuous process that has happened from time to time. Finally, just to give you a brief, sight on the Jammu and Kashmir Reorganization Act of 2019. As you all would know that this was also a very important milestone in the organization of states in India. Uh, Jammu and Kashmir enjoyed special status under the Constitution of India thanks to Article 370, and this was in the text of the Constitution because India had made such a promise to the King of Jammu and Kashmir before it can be brought to the Union Territory of India. And while we have taken away Article 370 granting special status to Jammu and Kashmir, you will notice that the 2019 order very clearly now makes Jammu and Kashmir as the territorial integral part of the Union of India. And to maintain that kind of a status, today Jammu, Kashmir, and Ladakh have been declared as union territories, and they are being managed by the President of India through the aspect of the central government. So, Article 370 has been taken off as the special status to JNK. JNK now becomes a part of India, which also clearly will tell you that the Constitution of India now extends to JNK. Earlier, if you notice that most of the legislations would say that, look, this is a law that applies to the entire country except to the state of JNK. Because JNK under Article 370 was given that kind of autonomy to decide what can be the law and regulation that is administered to that country, to that state, or to that territory. And hence, JNK had been given that kind of an autonomous status from the application of laws from mainland India or from the Union of India. So they could choose whether the same law will apply or with some kind of a modification. So Constitution had granted that kind of a special status to JNK as a state under Article 370. That has been removed. Now Constitution and all its provision apply to JNK, and all central laws inevitably apply to JNK, and JNK becomes as good as any other state for the administration of union and its territory. I think going further, one would look at the state and the union government. Now, before I move on to state and the union government, or the interrelationship between state governments and the union government vis-a-vis territorial administration, or what we call as territorial public administration, and the application of public policy. Because remember, public policy in union territories can be defined by the central government, whereas a part of public policy in the states is determined by the state government. So this territorial administration is left to the states, and public administration is defined by the aspirations of that state and that state government, and that brings India into a very interesting quasi, federal process. Uh, One must appreciate that in the previous slide, while I said that foreign territories can be this part, foreign territories can be acquired, conquered, or taken away under a treaty, or can be readjusted under a treaty. I think one of the examples that we should look at in terms of boundary or territorial readjustment through a treaty is the exchange of territory between India and Bangladesh. This is a classic example which happened post 2015, but the history of the same takes back to many years because India shares probably one of its longest boundaries with Bangladesh. In 2015, there was a constitutional amendment, which was the 100th constitutional amendment, and this was brought in to give effect to the acquiring of certain properties of territory by India and transfer of certain territories by India to Bangladesh. So India did transfer 111 enclaves to Bangladesh in exchange of 51 enclaves that India received from Bangladesh. So this long boundary between India and Bangladesh was attempted to be adjusted through this treaty between India and Bangladesh, through the agreement that was entered into by the two countries. This was entered in 1974. Interestingly. But the 100th constitutional amendment allowed such readjustment of the union territory. And you will notice that this 100th constitutional amendment also dealt with the transfer of adverse possession and the demarcation of nearly 6.1 kilometer border stretch area. And please note, these provisions did affect the territory of the following states, which is very important because please note, what the union does may affect state territory and state boundaries. There are four states that are having close boundaries with Bangladesh. First is West Bengal, of course, Assam, Meghalaya, and Tripura. And this was something that was very interestingly done in terms of the foreign territorial readjustment, as the case may be, and demarcation of what was required in that process. Also, not to forget, friends, when we talk about foreign territory, there were many princely states in India, and many of these princely states had to be cajoled to join the Union of India and hand over their territories to India as well. You will notice that as much as 552 princely states were within the geographical boundaries of India. And to be honest, of this 552, 449 joined India, but three did not. I repeat, 449 out of 552 joined India, and they were part of the Union of India. They handed over the territories to India, but three refused to do it. Who were the three? It was Hyderabad, Junagadh, and Kashmir. They refused to join India. However, in the course of time, slowly, I think government of India and the Union of India was able to convince Hyderabad and integrate Hyderabad. Junagadh joined India through a referendum. Now, this is very important because there are a couple of territories where a referendum was organized based on which they were actually integrated to the Union of India. And I think Junagadh is one, Sikkim is another. And Kashmir was, brought into the Union territory through the instrument of accession. So that is how the territories of India got integrated geographically. The princely states, most of them agreed. Three resisted, but slowly, I think all the three came around, and the geographical area of India was integrated as one. Uh, Also, you will notice that the first linguistic demand for a state was from the Telugu speaking population. This happened in 1953, and after a prolonged popular agitation and the death of a popular Congress leader called Sri Ramalu, I think he actually went on a hunger strike demanding the Telugu state, a state different from Madras state, and that is how Andhra became a linguistic demand of a state being created. So that is something that also can be taken note and consideration of. So yeah, these are some of the aspects that could be critical and important. And you will notice that which were the states or territory of states in 1956. By 1956, Andhra was there, Assam was there, Bihar, Bombay, Jammu and Kashmir, Kerala, Madhya Pradesh, Madras, Mysore, which turned into Karnataka, Odisha, Punjab, Rajasthan, Uttar Pradesh, and West Bengal. These were the territory of states that it created. If you notice from 1956, from 14 states that we had, now we have increased it to 28. Uh, what is the public policy in creation of states? For example, one may argue that the public policy in creation of state is that we realize that larger states are difficult to administer. Two, we have realized that states have to be created by linguistic and other ethnic and cultural considerations, and they get better managed when they are divided. So, smaller states, better administration, larger state may not be better administration. Three, I think the political process has been demanded on several occasions where the creation of states has been resulted in terms of the political process that was involved. For example, you will notice that the state of Nagaland had to be created because of the Naga tribes' demand, and to quell the kind of agitation and movement, a state like Nagaland got created in 1963. So these are unique issues and unique circumstances in which the creation of states did happen. Also, you will notice that Maharashtra and Gujarat were actually one state. And in 1960, again on linguistic line, the two states were divided because of the Gujarati speaking population's demand. And please note, Gujarat became the 15th state in the Union. So all of these are very interesting developments as one would see, and also one would also look at Sikkim. Now the history of Sikkim is quite intriguing. For the simple reason is that China does claim Sikkim as some kind of its territorial extension of land, and India has always said that Sikkim is an integral part of the territory of the Union of India. Now, the history of Sikkim goes back to again a princely rule that Sikkim was in, and Sikkim was is even now quite a remote, distant place in the Himalayan belt in the northeast, and it had a king that was ruling that place. And to be honest, the British ruled Sikkim, but once the British left, there was a choice in India to actually integrate the geographical territory of Sikkim. But Pandit Nehru probably hesitated in integrating Sikkim as a complete territorial land of the Union of India. Pandit Nehru at that point of time believed that doing so may, kind of antagonize China. And at that point of time, I think what the Union of India decided was they would make Sikkim as the protractor of India. So it is like giving protection and saying that, look, in Sikkim, if there is any issue of defense, if there is any issue of external affairs, or any issue of communication, then the Union of India will always be a protector of Sikkim. And for these purposes, India would support Sikkim, but for other purposes, Sikkim would be an independent and autonomous state. However, I think in Sikkim again there was a popular protest and a movement against the king and the princely rule, and India was forced to get into Sikkim and try and hold a referendum in Sikkim whether the people of Sikkim would want to join India. This referendum happened in 1975, and in that referendum, the people of Sikkim overwhelmingly voted for abolition of the institution of the prince and the king. And consequently, you will notice by the 36th, constitutional amendment, Sikkim was made a full-fledged state of India. So this very clearly also looked at a special provision in the constitution, which is called Article 371F, providing for special provision for the administration of Sikkim. But you will notice that this is how Sikkim was, or the territory of Sikkim was brought into the Union of India. Also, I think reorganization of states happens quite often in India, and the recent reorganizations we can probably take a discussion upon, and those are the creation of Chhattisgarh, Uttarakhand, Jharkhand, and Telangana. Now, in the year 2000, three more states were created. One out of Madhya Pradesh, where we created Chhattisgarh, two out of Uttar Pradesh, where we created Uttarakhand, and one out of Bihar, where we created Jharkhand. And these became the 26th, 27th, and 28th state of India. Telangana is the 29th state. We brought Telangana into by bifurcating Andhra Pradesh in 2014. Though both Telangana and Andhra Pradesh are Telugu-speaking population, again in terms of state reorganization, this was understood, and Andhra Pradesh was bifurcated due to cultural and regional issues. And Telangana happens to be the youngest state in India, but that is just the bifurcation of state and nothing more than that. Finally, also remember that, friends, as I said, that under Part 1 of the Constitution of India, states can be renamed. One should not forget that even some of the states have been renamed, spellings have been changed, union territories have also been renamed, so that the colonial British pronunciations or the way of calling it can be changed. For example, Pondicherry is now Puducherry. And the state of Mysore is now the state of Karnataka because Kannada, and that is the language. So why was it called the state of Mysore? Because the Mysore king was ruling a part of the territory of so-called Karnataka right now. So such kind of change of name can also happen, and interestingly, some of them have happened through constitutional change and constitutional amendment. For example, Orissa is now Odisha, and the state of Madras is now Tamil Nadu. So one should not forget some of these developments that did happen under the Constitution of India. Right. So there have been many acts that were passed, as I told you, through the recommendation of the president and the expression of the state legislature. These were mostly the so-called title was the State Reorganization Act, and the latest State Reorganization Act happens to be the J&K Reorganization Act, which bifurcates J&K into three, that is including Ladakh, and declaring the same as a union territory as well.